30 years ago, 1984, the Insurance Contracts Act was proclaimed. I wanted to call this session today, "It's the Law, Stupid," but Prorisk thought that was a bit vulgar and a bit excitable. I wanted to call the session, "It's the Law, Stupid," because 30 years after the enactment of that reformist legislation, it seems that the industry remains blithe, unconcerned, almost indifferent to a great many of its provisions. Staggeringly so, in my view. There are elements of behaviour within the insurance underwriting industry in particular that speak to a breathtaking absence of awareness of the provisions of fundamental legislation governing the relationship between insurers and their policyholders. Why do we have the Act? It's important to keep it in focus at all times. It was there to repair the imbalance, the asymmetrical position of power that existed between insurers and their clients. Strong, powerful, well-resourced, well-financed insurance companies acting in a manner that spoke other than to the utmost good faith. The Act was unabashedly reformist. At the time, the insurance industry was of the view that the Act overpowered the common law and produced changes of a decidedly unpalatable nature. I think not. But the Act was there to reform and modernise. Importantly, it was there to ensure that a better balance was struck, that it was, in a word, fair to the interests of both insurers and their policyholders. Historically, at the time the Act was debated and proclaimed, we had an industry where good faith had become notably confined in its application to the insured. It was of virtually no effect in relation to insurers. It was an archly legalistic, not at all well understood position in law that brought with it absolutely monstrous consequences, regardless of guilt or innocence, of the existence of fraud or of simple mistake on the part of a policyholder. Avoidance ab initio was the remedy. Claims were not therefore being paid. So today I'll look at issues around inception, around renewal. David will look at claims. Firstly, in terms of good faith, the Act incorporates good faith as an implied term in the policy, a fundamental change from the position of the common law that had prevailed for several hundred years. Breach, therefore, of the duty of utmost good faith constitutes a breach of the contract. Importantly, too, in terms of modifying and ameliorating the behaviour of insurers, a breach of the duty to act with the utmost good faith constitutes, under corporations law, a breach of that Act. So insurers, at the extreme end of the spectrum, should they continuously behave in a manner that's inappropriate in respect of utmost good faith provisions, are at risk of losing their Australian Financial Services licence. That is, of course, a very powerful, potent behaviour or modifier. Parties may only rely upon a provision in a contract if in doing so they are acting in the utmost good faith. The mere existence in the contract of a term or provision which confines, limits, constrains cover does not of itself confer a right for it to be exercised. Only if it's being exercised in the utmost good faith will a position be sustainable. In many respects, the most important provisions of the Act are those related to disclosures and representations during the negotiation of the contract of insurance, governed by sections 21 through to 31. Section 21, for the first time, mandated what material must be disclosed. It codified the duty of disclosure. The common law had provided great guidance for many years. The difficulty, however, was that the common law was not well understood in the general populace, both in small business and in households. It was not at all well communicated. Now we have a clear statement of what must be disclosed. All matters which the insured knows to be relevant to the decision of the insurer whether to enter into the contract, and if so, upon what terms and upon what conditions. If the insured wasn't aware that the material was relevant, would a reasonable person in the circumstances have been aware? So the emphasis was changed from a prudent underwriter test to a reasonable person test. As brokers, you'll all have read countless numbers of times the statements insurers provide regarding the duty of disclosure. It's not necessary to disclose matters that diminish the risk, that are of public knowledge, that ought properly to be known by the insurer in the course of its activities as an insurer. As brokers, you will obviously be presenting risks with the best possible complexion. You will highlight those matters that diminish the risk because you want the most favourable terms on behalf of your client. You'll be aware of what's happening in the world. You'll know that you do not need to alert an insurer providing travel insurance that there's a little bit of argy-bargy going on in Syria and Iraq and Afghanistan. But those are matters that are pretty much straightforward in terms of their complexion. Critical as an educative component of the Act is Section 22, which mandates that only if an insurer clearly informs the insured or intending insured about the nature and effect of the duty of disclosure will they be able subsequently to take action in the event of a failure. This is an archly legal duty that was not well known or understood. I'd suggest to you that it is still not well known or understood in small business and in personal lines insurance. So it's incumbent upon the industry, and you as brokers have a very significant role to play in this issue. You do have a role in educating your clients, in helping them to understand the legal framework within which the transaction occurs, and to ensure that they understand the duties that confront them in respect of disclosure and the consequences should there be a failure. But for the first time, a positive onus was placed on insurers to be educative and limitations of their rights if they didn't properly inform the insured. I think that a very reasonable and logical step forward. Section 23 addresses ambiguous questions. If a question is ambiguous and is answered in a way that is reasonable in an interpretive sense, no failure of disclosure or misrepresentation will be deemed to have occurred. Warranties of existing facts will be treated at law as misrepresentations rather than as breaches of warranty, and therefore give right to a strict right to avoid the contract. Certain statements, if the insured believed reasonably that the facts provided were true, although not true, will be held not to be misrepresentations. Section 27 addressed the old chestnut of a failure to answer questions being able to be interpreted by the insurer as a negative response, as a no. If an insurer frames a question, if the information is important, then it is incumbent, obviously, upon that insurer to obtain an answer. If it doesn't obtain an answer, then it forfeits its rights in relation to that issue. Section 28 provides the remedies. Section 28(1), if the policy would nevertheless have been entered into upon the same terms and conditions, despite the non-disclosure or misrepresentation, obviously it is sensible for the policy to continue. There is then no offence, no remedy available. That's one end of the spectrum. At the more severe end of the failure spectrum is fraudulent non-disclosure or misrepresentation, a deliberate, concerted or reckless failure to comply with the duty. In those circumstances, given that fraud is a crime in Victoria under the Crimes Act of 1958, obviously people should not be allowed to profit. So the policy may be avoided. And avoidance, of course, means avoidance ab initio. From the beginning, the policy will be deemed never to have legally come on footing. Most failures, however, will occur within those two extreme points of the spectrum and will involve innocent non-disclosure or misrepresentation. In such a case, the insurer will be placed in a position it would have been in had the failure not occurred. If an insurer is able to adduce to the court evidence that it would not, had it had the information, have entered into the policy under any terms or conditions, then it may evade liability entirely. Otherwise, in the absence of such compelling evidence being adduced, the court would impose a higher excess or a higher premium, as the case may be. Those are remedies that are born in equity. They are sensible and intelligent, far less draconian than avoidance ab initio, as was the case under the common law. Section 31, when it was proclaimed, led to industry outrage. The insurance industry howled like nothing I've ever heard, suggesting that this clause, which allowed forgiveness of fraud, would result in the floodgates being opened and in policyholders perpetrating massive numbers of frauds. To imagine that the judiciary, one of the most conservative elements in Australian society, people concerned fundamentally with the rule of law and propositions of law, would allow rampant fraud, was itself a disgraceful uttering on the part of the industry. No such thing has happened. Fraud will always exist at the margins. That's the nature of society. But if it would be harsh and unfair not to do so, a court may have disregard to the existence of fraud. The only case that I can recall of any great substance is Von Braun and Amy, where a guy lied quite deliberately about the purchase price of a Mercedes vehicle. The insurer would nevertheless have written the contract had they known the true cost, and the court, quite properly in my opinion, ordered the payment to be made. Permanent trustees. An FAI is one of the most interesting cases in Australian insurance law and law generally. Permanent trustees affected professional indemnity cover via Sedgwick. Their PI program expired on the 30th of September 1991. FAI wrote large chunks as leader of the first and second excess layers. Their total exposure to the program was $10.2 million. Sedgwick had become concerned that FAI security was not appropriate and resolved to remove FAI from the program if a replacement insurer could be found. The London lead on the primary layer sought further and better particulars from Sedgwick regarding the activities of permanent trustee and suggested, given that renewal started only in August for a major program expiring in September, far too late, that a 1-month extension was appropriate at expiring terms. FAI was asked to extend, but was not told in the negotiations led by Sedgwick that it was to be replaced if a replacement could be found. During the 1-month extension, a loss circumstance was notified. That did develop into a claim. Initial judgment was sought for $100.2 million. The matter settled ultimately for $36 million, which obliterated the first and second excess layers, involving FAI in a loss of $10.2 million, in respect of which it promptly denied indemnity on the basis that had its underwriter been aware that it was not to be offered renewal, they would not have granted or agreed the 1-month extension. Now, those of us who broke PI know no underwriter who knows he's going to be shopped in that manner, who's going to be used and abused, would ever agree to a 1-month extension. Why would they? They're on a hiding to nothing. The matter proceeded all the way to the High Court, whereby a judgment of 3-2, it was held that a distinction existed between matters that were commercial, that is, matters involving whether a company would enter into the contract, and matters affecting the risk. So a distinction was drawn by the High Court between entering the contract and accepting the risk. Commercial matters are therefore, as a matter of decided case law in Australia, not material. As an underwriter, of course, I have a very different view of the world. I think too as a broker that commercial matters are important. Because insurance professionals buy insurance for a lot of reasons. Excuse me, not insurance professionals, but professionals of all sorts. Some people buy insurance because of normal or ordinary prudence. That's the majority of purchases. In the professional lines area, a great many policyholders now are motivated not simply by normal or ordinary prudence, but by a need to observe contractual requirements. It's a condition of their relationship with customers, particularly with strong, powerful customers, that they have in force professional indemnity insurance. Those present some problems for brokers and underwriters because it may be that we can't see where the professional service is being provided and therefore where the exposure lies. Some people buy for the wrong reasons because they actually do believe that they're going to have a loss. CGU and Porthouse. Porthouse was a barrister. He provided quite incorrect advice regarding the ability of an injured person who was on a parole work program and was injured, fell down and rolled down a slope, damaged a shoulder, suggested that that person did not have a right to compensation under the Workers' Compensation Act. That was fatally flawed advice, quite incorrect. At the same time, Murphy being Murphy, legislative reform to the Workers' Compensation Act was passaged, introducing a verbal threshold under which anyone with less than a 15% impairment, of worst case, had no access to general damages. This was a matter that was handled quite badly by the solicitor and by the barrister. Porthouse was subsequently instructed to draft on the 26th of November a statement of claim, given that the legislation was to have effect on all actions. Subsequent to the 27th of November, that was lodged. An amount of $120,000 was sought. In 2003, the District Court ordered payment of that amount, but an appeal was lodged. That appeal was heard in August of 2004. In May 2004, Porthouse completed an application for professional indemnity insurance with CGU, in which he answered no to the question, are you aware of any circumstances which could possibly give rise to a claim? Excuse me. Subsequently, the appeal was allowed and the judgment was dismissed, at which point the injured worker mounted action against his solicitor and against Porthouse, eventually obtaining judgment for $170,000. CGU denied liability, denied indemnity, on the basis that the matter was a known circumstance. The High Court of Australia again had carriage of the matter ultimately. Its position was entirely clear. It is an objective evaluation, interpretation of circumstances which is to be preferred rather than the subjective evaluation of the individual practitioner. A reasonable barrister in the circumstances of Porthouse would surely have been aware that he had made significant mistakes in the management of this matter, mistakes of a nature that would give rise to liability, and that it was very likely indeed that a claim would materialise. Known circumstances remain the greatest problem for you as brokers in handling new clients and in handling renewals. Within your work processes, your relationship with the client, you need to be assiduous in establishing what facts they are aware of which may conceivably or possibly give rise to a claim. And if there is any doubt at all, err on the side of caution to protect your own professional indemnity exposure. Pech and Tilgals in 1994 involved an accountant who'd given some poor advice in relation to tax matters. The insured knew, and a reasonable person would or should have known that this would give rise to a claim. The issue, though, was did Section 52 of the Act apply? Section 52 is a catch-all that says that clever dick drafting isn't going to get you around the provisions of the Act. You can't drive a truck around this legislation through clever drafting. So the petition from the insured was, well, this is just changing the rules as far as disclosure is concerned. I didn't know it was going to be a claim. Absolutely no, so you can't be suggesting that I ought to. Well, that of course is rubbish. The policy had a strict, rigid exclusion in respect of known circumstances. This was a known circumstance. So the known circumstance exclusion will not be knocked out by Section 52. In respect of renewals and cancellations, Sections 58, 59 and 60 govern the law. Section 58.2 is very powerful indeed. General insurers in respect of expiring contracts must give at least 14 days notice of their willingness to negotiate renewal. If an insurer hasn't at that time provided notice of its intention to offer and negotiate insurance renewal, a statutory policy comes into force. So if you as a broker receive renewal documentations downloaded from an insurer 7 days prior to expiry, the insurer is in breach. That's not great comfort to you. You still need to maintain your relationship in a manner of equilibrium with the insurer. So you then need to get on your bike and get the renewal wrapped up pretty quickly. But if you don't have time, you should immediately go back to the insurer and remind them of the consequences of Section 58.2. It's a protection for you, it's a protection for your client. Very good broker I know bought herself a new Toyota, insured with Toyota's insurance company. Excellent terms and conditions, of course. During the insurance period, the first period of insurance, she changed address. She was an assiduous person. She notified them, kept records of the fact that she'd notified them of the change of address. Their systems dropped the ball. She didn't receive a renewal reminder. It was sent to the old address. 6 months later, of course, no mail forwarding at that stage. So she didn't renew the policy. Murphy, again, an unbeatable opponent, she had an accident 2 months after expiry, 3 months after expiry. Came to see me, asked me what she should do. I said simply ring the insurance company, remind them of Section 58.2, and if there's a problem, get back to me. She rang the insurance company, told them. An hour later, they rang back and confirmed that they would pay the claim. As properly they must. It's a very powerful section. Of course, as a broker, you would never miss a renewal because your renewal lists will be run at least a month in advance of expiry. Won't they, Quirky? Section 59 outlines the cancellation procedure. I keep highlighting this problem to brokers because of electronic transaction, particularly Sunrise transactions. Where premium isn't paid, the insurer will issue a notice of cancellation, generally not 97 days after inception, but 197 days after, because they tend to be inefficient. Often they'll tell you to cancel from inception. Do not do it. That cancellation will have no effect. As the agent of the insured, you would have to tell the insured they're cancelling this policy, but that cancellation is void. It's of no effect because it doesn't comply with Section 59. A minimum of 3 days, business days, prospective notice must be provided in respect of cancellation. Until the policy is cancelled, the absence of payment of premium doesn't vitiate the insurance contract. It remains on footing. It's simply a debt owed that can be pursued as a commercial law matter. So you need to get an ARN, you need to back out the entire premium, but the effective date of the cancellation cannot be less than 3 business days forward. Section 60 limits the rights of an insurer in respect of cancellation mid-term, only where there's been a breach by the insured of the duty of utmost good faith, where there's been a non-disclosure, a misrepresentation, a breach of policy terms and conditions, is an insurer able mid-term to effect cancellation, and then only in accordance with Section 59 on 3 days' notice, or longer if the policy so specifies. Otherwise, the insurer cannot cancel. An insurer, because it's changed its appetite in underwriting or because it's lost reinsurance support, cannot cancel a policy mid-term. Section 71 makes the point that all notices an insurer is required to give except notice of renewal are not necessary if a broker is acting. So you as the broker have the role and the duty regarding Section 21 and Section 22. It's to you as brokers that the duty falls to inform your clients about the nature and effect of the duty of disclosure, to ensure that they understand that duty and its consequences. Insurers, however, must produce a notice of expiry. Section 66 limits the rights of subrogation against employees. If an employee is acting other than in a reckless or willful misconduct manner, an employer will indemnify the employee and insurers will have no rights of subrogation. Very important in respect of professional indemnity, where you have employed professionals who fail in their professional duties. Unless the conduct giving rise to the claim is willful and reckless misconduct, no rights of subrogation will apply. Section 75 outlines the fact that where a policy has been declined or cancelled, insurers, upon request in writing, must provide reasons for that action. Generally, as brokers, you'll be well aware of the reasons. The Insurance Contracts Act is now 30 years old. I wish I was 30 years old again. As professionals, you must know and understand the important provisions as they relate to your relationship with clients. As professionals, it's incumbent upon you to have a ready day-to-day understanding of the provisions that I've spoken about and those which David will now address for you.
Pleasure to have you here, and a pleasure, of course, to be talking with Gary Gribben on the Insurance Contracts Act. This is called the 4 things brokers must know about the Insurance Contracts Act. I actually think I only talk about 3, but anyway, you won't pick me up on that. And of course, on your chairs, there is a copy of the PowerPoint. There's also a paper that I've done which analyses some of in more detail, some of the cases and also some of the current issues. So what's in store for the next 20 minutes? Well, I'm going to give a few claims examples. Now the Gribbo's set the scene. I am going to talk about utmost good faith, and in particular the most recent High Court case which considered that in detail, which is CGU and AMP. I'm going to talk about the introduction of the concept of prejudice that came in the Insurance Contracts Act in 1984. I'm going to talk about notification of claims and circumstances and the current controversy, where that's going. And I'm also going to talk briefly about broker commissions at the end, and of course in the middle there'll be that bit where I do gags that make you all feel a bit uncomfortable. So wait for that one. Okay, the duty is set out under sections 13 and 14 of the Insurance Contracts Act. The section 13 imposes that as an implied term in every contract of insurance, and section 14 says that provisions of the insurance contract cannot be relied on other than in the utmost good faith. So what does utmost good faith actually mean, and what does it actually mean in practice? Now, there was an early example, one of the first cases dealing with this provision. I think the Act it's called 1984. I think its effective date, though, was actually, I think, in early 1986. But I haven't checked that. That is history. But it was Australian Associated Motor Insurers and Ellis. This had a policy condition which obliged the insured to notify the insurer of modifications to the vehicle, otherwise the insurance lapsed on the point at which the modification was made. And the insurer denied indemnity, and the South Australian Supreme Court, considering that, said, look, under the terms of the contract, the denial of indemnity is perfectly legitimate, but because you have not sufficiently made this term aware to the insured, we're not going to let you rely on it. And that was held to be a breach of the duty of utmost good faith, in that you have not really had proper regard to communicating key policy terms to your insured. So that's a good neat little example. We have a much more complicated example in financial lines from the High Court case of CGU and AMP. Now I'm going to go through this in a bit more detail, The key part of this case is not, there is a quote that I'll get to about what the duty of utmost good faith is, but the case wasn't really decided on utmost good faith. That if you say there's a breach of utmost good faith, one of the things that the law has always struggled with is, well, what's really the consequences of that? But that's not really why it's important. Why it's important is that every policy issue or every dispute you have between an insurer and insured is going to be looked at through the lens of utmost good faith. So it sets the standard and it sets the method of interpretation. So you don't often sit there going, oh, Jesus, God, you know, that's a breach of utmost good faith. It's more like, well, no, we're going to interpret what the proper solution is to this issue in the utmost good faith. So it's a subtle difference that the courts have always struggled with. So this is a really good example because it wasn't decided. There didn't end up being any finding by the High Court ultimately that either party had acted in a breach of the utmost good faith, but it definitely informed the solution, which was ultimately in favour of the insurer. Now, going back over the facts, and a lot of you will be familiar with it, but let's just revisit it. There were 63 investors that lost money. They were clients of rogue financial advisors, and relevantly, those financial advisors had, over a period of time in which they'd effectively fleeced the money, which wasn't huge. I mean, it was a bit over $3 million. They had an AFSL with a company called Hill Ross Financial Services. They also had an AFSL with AMP. And one of the critical parts of this is there was actually a period where they had an AFSL only with Hill Ross Financial Services and not with AMP. Now, Hill Ross Financial Services went under and it had its insurance with HIH for a period. ASIC had notice of these claims. They went to AMP and put pressure on them, the kind of pressure that a regulator likes putting on. It's the kind of pressure that APRA could put on any of the major banks if they're seen to be below their high quality liquid assets ratio, which is a critical part of the reforms to protect us from another financial crisis. And for you guys, who are all AFSL holders, I mean, you lose your licence, you don't eat, you know, you can't work. And so this was AMP, which makes, you know, hundreds of millions of dollars off its licence. It's got ASIC, who's got the power to pull that licence, saying, sort this out. Right? So a protocol was agreed with ASIC in April 2001. There was notification to the insurer at that point, and then there was a meeting on the 5th of October 2001 with the claims team of CGU and also AMP, you know, barristers, etc., and they said, right, we've got 63 investors that are making claims. We've agreed this protocol with ASIC where we're going to pay them out. Is that okay? To which CGU, and the content of that meeting was disputed, but it was ultimately accepted that CGU said, well, look, do what you need to do to protect your own commercial interests, but act as a prudent uninsured because a decision hasn't been made about indemnity. And that was really critical. So then AMP moved swiftly. They settled 61 of the 63 claims at a total cost of $3 million. Then they made a claim for that under the policy, and then by March 2002, CGU had enough information, seek advice from Alan Archibald QC, and Alan's view was that AMP was not liable to these claims because it had a valid defence under Section 8194 of the Corporations Act, which was effectively that at the relevant time, these people were not licensees of AMP, they were licensees of Hill Ross, and that AMP was not vicariously liable for their actions. Now, a key feature of this case is that AMP did not actually challenge that advice and didn't run the case on the basis that that advice was wrong. What they did was say, look, we've acted reasonably in sorting out this problem, CGU, you should pay, right? And so they litigated initially in the federal court. Justice Heery found in favour of the insurer, and in my paper I set out the key quote from Justice Heery, where he's effectively saying, look, I just find that AMP, you went ahead to protect your own interests and you did not have legitimate regard to the interests of the insurer in now saying that you can expect them to pay. That got appealed to the full court of the federal court, and the full court overturned. Now, one little feature about the full court of the federal court, and I've had a complaint about this recently when I've had the opportunity to get in the ear of some judges. The full court has, I think it's about just under 40 justices Australia-wide. When an appeal is made, the full court is constituted from any of those 40. Right? So it's a real crapshoot. And on top of that, I don't think the full court, when it gets together, has due regard to the fact that the trial judges sat there and listened to all the evidence and actually made the decision. They sort of go in and think, shit, would I have made the same decision? Having a look at these appeal papers, no, we'll roll them, right? So the full court's got the highest percentage of, well, certainly higher in Victoria than the Court of Appeal, which hears appeals from the Supreme Court, where we generally have about 7 judges. Sometimes they get another one co-opted, and those 7, we know that there's really only 2 or 3 that pretty much shape judicial opinions. So we've at least got a great, it's much more predictable, whereas the federal court really is unpredictable. And this is a good example because the full court overturned the decision of Justice Heery. The leading judgment of Justice Emmett held it was a breach of utmost good faith to actually stand by while the claims were settled, and not say in extremely loud and firm terms that indemnity has not been accepted, and actually we think you should be availing yourself of a defence that you don't seem to be saying that you have. And that, now there's a point missing there. It should say lack of proprietary interest to establish breach of utmost good faith. So he said the view of the full court was that you don't have to show dishonesty, you just have to show a lack of consideration for the interests of the insured to make out a breach of utmost good faith. And that is a very important concept that I'll get to in a moment. So anyway, so at the end of that, you really had federal court judges 2-2, completely divided on this issue. It was then argued before the High Court on the 7th and 8th of February 2007, and the High Court found in favour of CGU in a 6-1 verdict. Justice Kirby, who interestingly was actually at the Law Reform Commission when the Insurance Contracts Act was drafted, was the dissenting judge, who took a much more expansive view. Now, the decision's possibly more relevant as to this idea of whether or not an insurer can sit on the fence, and I don't think that does justice to what CGU were doing at the time. And I deal with that in some detail in the paper. But insofar as the court commented on whether or not there was a lack of utmost good faith by both parties, this is really the key quote coming out from the decision of Crennan and Gleeson. And I'll start down the middle. The classic example of an insured's obligation of utmost good faith is a requirement of full disclosure to an insurer, that is to say, a requirement to pay regard to the legitimate interests of the insurer. Conversely, because obviously the duty of utmost good faith goes both ways, conversely, an insurer's statutory obligation to act with utmost good faith may require an insurer to act consistently with commercial standards of decency and fairness, with due regard to the interests of the insured. Right, with due regard to the interests of the insured. And that's what the insurer has to do as well. And such an obligation may well affect the conduct of an insurer in making a timely response to a claim for indemnity. Okay, so what does that mean in practice? Well, this is the way I interpret it, and I think it works. Firstly, it requires the insured and the insurer to have regard to the legitimate commercial interest of the other, right? And it makes clarity very, very important. Second point is, and how do I actually do this day to day? Well, as you know, if we're appointed by an insurer on a claim, we're usually meeting with the professional person. I have a meeting with them without prejudice to insurers' rights on indemnity. Right? In the US, you wouldn't be able to do this. Right? In the US, you've got claims counsel and coverage counsel, and they just don't let it meet because you have damages, consequences for bad faith and the like. Reality is, in Australia, we can't afford 2 sets of lawyers on everything. Right? So I'm in this position that inherently has conflict. I'm going to receive all this privileged information from an insured. They have to tell me it, pursuant to their duties under the policy, but also pursuant to their duty of utmost good faith. And then I can take that information, effectively turn around and tell them they're not covered. Right? So it's a difficult relationship. The duty of utmost good faith in this relationship is extremely important and something that I take great comfort from, and the insured does as well. So when we're sitting there, I say, look, as I explain that I'm appointed, without prejudice, and I say the insurance contract is one of the utmost good faith. It means that I will act towards you with complete honesty, and I also have to have regard to your legitimate interests. So if I think there is something that is going to assist you, then I will say so. If I think there is a problem, I will say so as soon as I can. And once you actually get that out of the way, you get the right discourse, and it really does minimise disputes. If you sit there, don't discuss an indemnity problem, then pull the rug out of them 14 days later when you deny indemnity, obviously you'll have problems. Now, just you might remember, who was here at May? Anyone want to put their hand up? Anyone remember my story about the Rolls Royce, or you completely, okay, you don't, that's fine. This is a mate of Mum's, who's a physio, took up with a lady, he's 75, she's a sprightly 76, I think. Turns out she's one of the wealthiest women in London. And they've got this Rolls Royce that you can probably see there, but the number plates are 007. Her husband was widowed, and he was driving around in that, and someone stopped him at the lights and offered him £1 million for the licence plates, to which he said, well, what am I going to do with that sort of money? I'm living in Belgravia Square. So it was just an example of how someone can get lucky. The point of this was that when this national seminar series goes around, my other presenters didn't read my briefing notes on it and had no idea what I was talking about. And they said, oh, I don't know what he's talking about here. I then actually went to London about 2 weeks later, and I actually had to drive in the car. I had a photo of me standing in front of the Rolls Royce, which I was going to show you all, you know, a bit like using it as a holiday snap. Unfortunately, I've lost the photo. But I still like the idea, you know, that my co-presenter's got no idea what I'm talking about. So I've got this slide coming for them next. Now, I just want to see what they make of it, you know. They're going to think, hey, what, there's 10 things? In total. That lady is Mary Roach, who, and this is from the TED series. I don't know if anyone follows that on YouTube. It's a really, presentations to stimulate debate, and she's one of the most respected science writers, and it's an absolutely fantastic presentation that talks about the science of coupling. Really to promote her book. And I thought I had a very good example of the duty of utmost good faith, because one of the things she refers to in this presentation is the theory of what is the evolutionary purpose of female orgasm. And she looks at the equine industry and then also at the, I don't know what the pig industry would be called, and there were studies that if the sow is actually stimulated during artificial insemination, there was an 8% increase in conception rates, and so in the farming industry this was extremely important. So she then provides this video, and I've actually thought better about playing it in front of a room, because I thought, all of us sitting here watching a farm stimulate a sow is really just going too far even for me. But I am going to be really interested to see what my colleagues do in each state. But I thought it was, when you actually see this, you'll get this electronic. I'd just encourage you to get onto that video and think it's David's example of utmost good faith in practice. But you'll laugh really loud when you see that video. But I'm going to resist the temptation to play it. I mean, I am being filmed, aren't I? Okay.
And just for future reference, the pig industry, mate, is known as the law.
That's right. Or you can actually look at that video and wonder which one's the underwriter and which one's the broker. When you do get interested in sow stimulation in the farming industry, which of course I am now, you'll actually see that things have developed, and there's now a sort of this black plastic thing that the farmers now use so that they can actually put it on the back of the sow and stimulate 4 at once. So they've got that same farmer, who was, sort of hopping up and down on the back of this sow, is now putting these, things on the backs of the sow and being able to do 5 at once. And he looks extremely proud of himself being able to achieve that objective. All right, enough of that. One of the key concepts that came out of the Insurance Contracts Act was really this concept of prejudice, that insurers cannot avoid paying claims unless they really show that it matters, right? And really key to that, there are 3 provisions that have the same concept introduced in different ways. Section 54, which has been the most problematic, Section 28.3, which sets out remedies for non-disclosure, and 56.1 for fraudulent claims. Now, I'm going to talk about this. That we all know in financial lines that Section 54, the most controversial part of it, is all about what are the consequences to failing to notify a claim or failing to notify a circumstance. Now, the key thing about Section 54 is that it only applies to an act that occurred after the contract was entered into. Right? So we're moving after the inception of the policy. Non-disclosure is all stuff that's done before, right? But in claims made and notified policies, we get this unusual sort of situation where if you're aware of a circumstance and you don't notify it, what are the consequences? And really, is Section 54 going to come to your rescue? Now, Section 28.3, and sorry, one of the key things about this is that you can't avoid to pay a claim. for something done after the inception of the policy unless the insurer can show that it's caused them prejudice, right? And that can be very difficult to do. Well, it's very difficult to do. And in relation to 28.3, the remedy for non-disclosure, it's a similar idea. The liability of the insurer can only be reduced to put you in the position you would have been had the non-disclosure not been made, which is evidence from an underwriter that I would have not underwritten the policy, or I would have written it on different terms. Now, I deal with this quite a bit in the paper. It is very clear from Porthouse that known circumstances exclusions will be upheld, right? So that if you fail to notify something prior to the policy period, then that exclusion is going to be given a common sense interpretation. And I have to say to CGU, congratulations for picking the right case to run. It was the right case to take to the High Court. The more important issue, and this is what is silent in Porthouse, and we don't really know why it happened, but what about the insurer that was on risk when Porthouse filled out the proposal form? Right? At that time, he had a circumstance that if he had notified his insurer, and I'll move forward a bit, if he had notified his insurer under this section, Section 40, subsection 3 of the Insurance Contracts Act, that insurer would have been on risk, right, in relation to that claim when it arises. But he didn't do it, right? So is that failure to notify something that is cured by Section 54, right? Is it an act that occurred after the contract was entered into? And if a failure to notify a circumstance is such an act, then what is the insurer's prejudice? Now, you can forget you can forget prejudice, right? And I talk in the paper about Australian hospital care, which a lot of you people will remember, where it called the policy a discovery policy. The Insurance Council of Australia commissioned an actuary at that time to say, okay, can we show prejudice suffered by insurers by reason of failure to notify on PI policies of claims and circumstances? And they said, no, you can't. It's just impossible to do on any actuarial basis. So there's no issue about prejudice. The issue is the failure to notify a circumstance something to which Section 54 applies? Now, after Australian hospital care, and I'll just stick on this section for a moment, after Australian hospital care, what Australian hospital care had found was that in relation to this Act, where the policy has an obligation to notify a claim, or the policy has an obligation to notify a circumstance, then that is an act. It's really a breach of the policy conditions, and that's clearly what Section 54 was designed to do, right? Because people who practice a lot in this area know what did the insurers do after Australian hospital care? They removed all obligations to notify a circumstance and all obligations to notify a claim, but policy wordings are now coming back into the market, giving an obligation to notify a claim. So, sort of counterintuitively, you have a breach that is covered by Section 54. So if you fail to notify a claim, it's okay, you can look back, but if you fail to notify a circumstance, we're sort of still in no man's land, because you're a bit of an idiot if you draft an insurance policy that has an obligation to notify a circumstance. Similarly, if you're a broker, look for the obligation to notify a circumstance, and you've effectively got coverage for when the notification should have been made as opposed to when it was. Now, but what is the High Court going to do with this? Are they going to give Section 54 this, broad right? And there's just been a case handed down about Section 54 in different circumstances just in the last month. Maxwell and highway hauliers. Highway hauliers under fleet of vehicles. The policy provided cover for accidental damage, but there was a clear endorsement that said there's no indemnity unless all your drivers are PAQS assessed. This was a particular assessment score. Of course, they didn't have PAQS assessments done for all of their drivers. There was an accident. Maxwell, who's a Lloyd's underwriter, denied indemnity. Highway hauliers said this is an act. Our failure to organise the PAQ assessments is an act to which Section 54 applies. And the High Court said absolutely. Right? And very clear from that decision that they will give Section 54 the broadest possible interpretation. And so this is why utmost good faith is really even more important. So Porthouse is still good law for failure to notify a circumstance, but exactly whether or not the courts are going to permit insureds to look back on a failure to notify a circumstance is still up in the air, and that's why for brokers, notification of circumstance is still your biggest risk, right? You do have this section, which is a statutory right in favour of your clients, okay? If they notify those facts, then it's all done. Whenever the claim arises, it could be years later, that insurer is still on risk, right? If you fail to avail themselves of that section, then the consequences are they could well be without a claim that they should have had cover for. And as everyone knows who deal with claims, for every 10 notifications of facts, really only about 1 to 2 translate to claims. So it's something to be done looked at conservatively. Now, just quickly on types of notifications. It can't be so broad as to be meaningless. I hereby notify of all claims I might receive relating to any advice I have given concerning a tax-effective investment prior to 30 June 2006, right? Or Company X has gone into liquidation and I might be sued in relation to any valuation I provided to them. I've actually had 2 cases with those notifications. That just won't cut it as a notification of circumstances under Section 40. Very briefly with Section 56, the section says that effectively if there's only minimal fraud in relation to a claim, the court's got discretion to effectively excise the fraudulent part and still pay the genuine part. There was, as Gary says, outrage at the time it was introduced, but there was a feeling that at that time insurers were getting away with too much by a little bit of a problem going a very long way. And really that provision mainly has been used to assist innocent co-insureds, so you've got a often a husband and wife team. Husband lies a bit in relation to the claim form, wife doesn't know anything about it. It was used as a basis to avoid the claim completely. Well, the wife's legitimate interest is still going to be looked after, and that's this case of MMI and back 2. But really nowadays the courts take a dim view of fraud at any level, and I think it's much more likely now that 56 gives the court a discretion to avoid it, but the way I read the judiciary at the moment is that, a little bit of fraud still can go a long way, and Section 56 is not frequently relied on. Now, last 2 minutes, briefly, just a quick comment about broker commissions, right? Because I've just been arguing a case in the Supreme Court about an accountant who didn't disclose the argument was that the accountant hadn't disclosed to its clients how much commission they were receiving on an almond scheme investment that they were putting their clients into. And the argument was that this was a breach by the accountant of fiduciary duty, and the person making the argument was an insurance broker. So we got very interested because we're going to cross-examine this insurance broker on the fact that they don't disclose the 15 to 22 points they were actually receiving in commission on the PI policy they were writing for the accountant, right, who I was representing. Now, the case settled and we never got into this, but Peter Reardon did say to me, who's a senior counsel, he said to me, how do brokers get away with it? He said, I don't get it. Like, how do they get away with not disclosing the commissions they are paid from insurers, right? Now, we all know, so the way it actually works, back in 1984, the Insurance Agents and Brokers Act was enacted at the same time. It was repealed in 2004 by the Financial Services Reform Act, but as you know, brokers all came in under Chapter 7, right? And so you're now like all other, providers of financial products. Now, all brokers have to have an AFSL. ASIC Regulatory Guide 146 covers required training levels, and it also imposes an obligation to manage conflicts. Now, in relation to disclosure of commissions on retail products, home motor, etc., there is a general form of wording that discloses the commissions that everyone's happy with. But in relation to financial lines policies, which are considered to be a wholesale product, you're not obliged, you do not have a statutory obligation to disclose those commissions, right? And just go back in mind, I don't know if anyone remembers the Spitzer prosecution of Marsh back in 2001. It was all about failure to disclose trailing commissions. The prosecution ultimately didn't succeed, but at the same time ASIC in 2001 did a review of the insurance industry and basically said you're all doing the right thing. So there's no obligation, no legal obligation, but if you look at all of the pressure that other financial service providers are under at the moment over disclosure of commissions, don't think you're going to be immune, right? So financial advisors are getting hammered on the commissions that they receive, upfront and trailing, on recommendations of products. You've got the banks getting lent on over problems with Storm Financial and all of that sort of stuff. Don't think the insurance broking industry is going to be immune. And also, there is an obligation to manage conflicts of interest, right? And so let's just say you've got a new entrant in the market paying 40 points, right? But you think the policy is inferior, right? Or might be inferior to the standard tried and true that's paying 22, right? That is a conflict of interest, right? Your financial interests are going to potentially put your client at risk, right? Now, be very clear about the way the courts are going to view this, right? And in the class action environment that we're sort of walking into, with the Productivity Commission recommending that contingency fees be introduced in Australian law, I don't think that's going to happen, but non-disclosure of commissions is going to be a hot topic for the plaintiff firms. That's what they're going to be looking at. And if you're in that situation, make no mistake, a court will say that's a conflict of interest. If you're going to move to an account where you're getting 18 points higher, right, you'd better make sure that the policy is just as good as the one that's offering you 22, and be really certain about it, right? And that is the kind of situation where you might think that disclosure is appropriate, but let's face it, no one's going to do that, right? That's the kind of thing you've got to be aware of. What usually happens is that someone trying to get business on that basis, the brokers go back to them and say, well, you'd better trick up your wording and make sure it's good, because you are putting us in a difficult position with our clients. So you've got to ensure your client is getting the right policy regardless of the commission paid. So, key messages. Can't really call yourself a broker doing financial lines unless you have a working understanding of how sections 13, 29, 28, 40, 54, 56, 58 and 60 work. The intention of these provisions from the reforms and routinely implemented by the courts is to support common sense and fair play and keep an eye on disclosure of commissions to clients. Your financial interests cannot compromise the quality of your advice. Thank you very much for listening.
As brokers, get very concerned about leaving the client uncovered. So in the absence of instructions, often brokers will go ahead and issue renewal instructions. And then 3 months later, the client hasn't paid. And if it's a large lump of premium, the insurer may pursue the client. And in such circumstances, one would expect, if the client has good legal advice, that they would join the broker, and ultimately the broker will pay that premium, because the broker has acted without instructions. Ray Lundy?
Yeah, two things. What happens if you ask your client for instructions and you don't get it?
Then don't do anything?
That would be true. Already, as of yesterday.
There's a famous
so can people hear the question down the back?
Yeah. And
yes, no? All right, Ray, sorry, I'll give you a microphone.
I hate talking to these things. The question was, what happens if you send out your information to the client and you're waiting on an answer and he doesn't respond?
Right, there's a very famous case involving someone you know quite well, Charles Macmillan.
Yes.
Some years ago, very well-established proposition in law. Charles sent out 2 renewal reminders to a client. The client chose to ignore them. Policy was not renewed in the absence of instructions. The client had a prang, wrote his vehicle off and sued Charles, and the court reached its decision very, very quickly. The broker wasn't there to insulate the client from its own stupidity. Charles had done everything that was reasonably required of a professional party.
Just make sure your file looks good.
Yeah.
And that, like in professional, all professionals, you've got your problem clients, and, you've just got to prioritise the one. And if you're getting into renewal time, which is obviously your point of biggest exposure, and you've got someone who you just don't have the right rapport with, or don't have, you exit them as clients, or you make it very clear in writing what the consequences are of their inactivity, and that'll get you home every time.
The other question I had was to do with the interim cover.
Okay,
Yep.
Interim cover. Can I take?
Yeah.
I'll take it. Yeah. Yeah. Okay. Ray's asking about interim cover. I'm assuming you're talking about when there's a failure to provide a renewal notice, or you just.
No, you've quoted them.
While it's on
Okay, I'll hand over to Gary on that.
Interim contracts of insurance, that is cover notes, can be cancelled at any time.
Yeah, all right. Yeah. Just want to clarify that.
At the back, sir.
A policy was renewed on its due date between the client, between an insured and the broker and the insurer. During the period of and the premium was paid. And during the period of insurance, the insured, for reasons best known to them, decided to sign a letter of appointment and transfer their insurance portfolio to an alternate broker. The broker that it went to didn't have a facility with the original underwriter And so the underwriter has advised the client that the policy will be cancelled within 30 days.
Good luck. I don't believe I saw that as one of the reasons for cancellation under Section 60.
My understanding would be that if they've paid the premium, that's for a 12-month contract.
The policy will remain on footing. There is not a valid reason under Section 60 for the insurer to cancel the in-force contract.
What about at renewal? What would happen then?
At renewal, they can decline renewal 14 days in advance.
So the mere fact that broker, sorry.
Nothing I say constitutes legal advice, of course.
But I'm happy to give you but what I say does.
David's in the business of providing free legal advice. He has more than adequate professional liability coverage.
So the mere fact that the broker, the newly appointed broker, doesn't have a facility with the underwriter, doesn't provide scope for the underwriter?
Not at all. It's a matter of privity of contract. The contract exists between the insured and the insurer, not between the insurer and the broker.
No, they've got to get within the rights of cancellation under Section 60, which are very limited. Non-disclosure, misrepresentation, fraud. It's none of that. Yes, yes, please.
Just wanted to ask a question on cyber insurance. It's obviously a key risk and big issue for financial lines brokers. It looks like the speed to market of some of these insurers have brought US or overseas drafted policies to this market. For example, one of the current policies has a requirement to notify a claim within 60 days of the event occurring, and there being no cover thereafter. There's claims made for some clauses, there's occurrence on other clauses. What issues have you seen to date, or have you seen any claims in this sector?
Short answer is no, it's still too early. It's a bit like environmental impairment liability in its time, other forms of pollution cover, other exotics. The wordings and the manuscripts currently out there are particularly varied. It's not a space in which Prorisk plays, and I don't think there are any plans in the short term to move into cyber risk. I would hope there aren't, but I'm only underwriting director. The policies that are available tend to be, somewhat lacking in clarity, and you do need to be careful. All of the issues that you've raised, however, are addressed by Section 54, and some of them may flow into good faith issues in terms of the interpretation and application of the policy down the path. The good news for you, not that I'm here to produce advertisements for other companies, is that some local policies are now being released which I think are better considered and certainly better priced.
Certainly, I have had experience.
That'll be your phone, right?
Tell them they better give you instructions, Ray. And I've got a Peg video for them. Blair, no, look, I have had experience of these, and it really is interesting, and it is going to be no doubt in my mind, an emerging market, particularly about data protection, the use of cloud services and the proliferation of them, and their vulnerability to events like hacking. And to give you an example, Salesforce, which is becoming the dominant cloud provider of client management software systems. I mean, talking to the guy who looks after that, just happens to have swimming lessons with my kid at the same time, and they can't afford to have their servers down for half an hour. The consequences of that is millions and millions of dollars just in people not having access to their systems for half an hour. And this is stuff internationally. It's not limited to Australia. It's anywhere. So there's no, and the existing liability policies don't deal with those risks well enough. So I think it's screaming out for a tailored solution. And the issues you raise really about this hybrid of occurrence and notification. I mean, really the way I look at them is that they're not PI policies. They don't really have the same issues about notifying claims. Usually in a cyber problem, there is an absolute disaster that you're telling everyone about at the time. It's pretty unusual that there's a problem and you don't tell anyone about it for 1 or 2 years and then come and ask your insurer to pay $1 million, right? So at the moment, I think they're just going to go to an occurrence-based wording. But then what do you do with Maxwell, you know, which effectively says you don't really need to do this? And I think it will evolve to the point where the clients will actually sign declarations as part of it, that they will immediately notify of these problems when they arise, so that you won't have that issue of, you know, being asked to pay a lot of money years later.
I suppose the only thing I'd say to that is that are you saying on a current space, the liability section of the policy might move to a current space?
Yeah.
Yeah, okay. Because you do still get the issue with security or privacy breaches where you might notify a circumstance and that develops a number of years later.
Yeah, look, that's a very good point. That's a very good point. It is an evolving market.
But you haven't seen any claims?
No, we've seen claims. Yeah, definitely. No, I've seen claims. Probably have a discussion about the circumstances of those. Very few. But, you know, the products in my experience have only been around 1 or 2 years. I was talking to someone a week ago who said they've been writing them for 8 years, but that's probably because they haven't had any claims.
Do you keep in mind that what the Lord giveth, the plain English policy taketh away?